course of human events. In our last session, we looked at the foundations of the modern administrative state, a basic rejection of the founders' constitutionalism of separation of powers and of limited government. The modern administrative state was an attempt to base policymaking and implementation as much as possible upon disinterested scientific and technical expertise, which they claimed was necessary in light of the complexities of modern industrial society. The reality of the modern administrative state, however, was far different. And in this lecture, we're going to look at two critical aspects of the modern administrative state as it actually functions today. The first of these is the notion that the administrative state is anti-constitutional. We'll see that its defenders are openly hostile to the Constitution, that it allows for myriad methods of policymaking, and that in reality, at the end of the day, it represents a return to pre-constitutional government. Our second area of focus will be that the administrative state today is, rather than the aristocracy that the progressives hoped it would be, simply an oligarchy. It's the rule of the few for their own sakes, a distinct and insular class of people, rather than a trained elite, corrupt and distant from the people whom they rule. They're supported by a coterie of clientele groups who depend upon the modern administrative state for privileges and benefits. The average person in this system is systematically and fundamentally disenfranchised. Policy is not made for his benefit, and he is largely unable to control the machinery of the state. In sum, the administrative state is the antithesis of constitutional government and cannot even live up to the expectations of its progressive founders. Now, with regard to our first major area of discussion today, the idea that the administrative state is anti-constitutional. One can look even in the popular media at prominent legal scholars and prominent intellectuals on the left, and it becomes obvious very quickly that they are openly hostile to the Constitution. Prominent law scholars like Sanford Levinson and Harold Seidman say very plainly that the framers were willing to junk the Articles of Confederation, and we should be willing to junk the Constitution just the same. The system is dysfunctional. It prevents us from having anything like a real government at all. We can't have unified control of policymaking by one party or one group, and therefore all we have is endless gridlock and dysfunction. One of these scholars, Harold Seidman, also says that the Constitution is full of, quote, archaic, idiosyncratic, and downright evil provisions. Now, with regard to the modern administrative state, this same group of people tells us that we should stop being so concerned about formalities of the Constitution, like the separation of powers, and more concerned about making the machinery of government work in the modern world. Separation of powers, they say, doesn't help us deal with the exigencies of modern governance. And besides, we should stop pretending that we can so neatly partition the functions of government in the way that Madison said that we could in the system of separation of powers. Another way to think about the anti-constitutionalism of the administrative state is to recognize the fact that the administrative state intrudes upon even the minutest aspects of people's lives. One prominent example from our recent politics is the idea that the federal government, the federal bureaucracy, is going to dictate to individuals and to employers and others what has to be included in a healthcare plan which can be legally sold in the United States. But there are all kinds of other examples that you encounter every day and perhaps aren't even aware of. The federal government dictates the amount of water that you can have in your washing machine and in your dishwasher. The federal government dictates the content of the light bulbs that light up your house in the evening. They dictate the composition of the spouts on the gas can that you use to fill your lawnmower. They've determined that the ordinary gas can spout allows for too many fumes to escape. And so instead, they created a system which is all but impossible for the ordinary person to use and probably causes more spills anyway. The federal government dictates to the manufacturers of step ladders the angle at which the ladder must be placed when they test it for the sake of determining its weight rating. Meanwhile, we might note, the administrative state seems to be sincerely uninterested in performing the tasks that our founding fathers expected legitimate government to perform. Major cities have chronic amounts of unsolved murders, which they never seem to bother to get to in many cases. The city of Detroit discovered several years ago a backlog of thousands of unprocessed rape kits that took more than a decade to finish. The mayor of Portland, Oregon seems perfectly content to allow Antifa to take over the streets of the city and to enforce the laws themselves. And Portland is one of a number of examples of progressive cities on the West Coast which also seem perfectly content to allow their cities to become mountains of drugs and human excrement. At the national level, our government, or at least much of our government, seems to be deeply unconcerned for maintaining our territorial integrity in the face of thousands, if not millions, of illegal immigrants coming into the country, and thus unconcerned with protecting the basic sovereignty of the United States. So that's another way that we can think about the anti-constitutionalism of the administrative state. That is to say, it inverts its priorities. It becomes intensely focused on things that legitimate government ought not to do, and it neglects the things that just government should do. Another way to think about the anti-constitutionalism of the administrative state is what I like to call polymorphous policymaking. And what I mean by that is that there are so many more ways to make policy in the United States than the one way that is dictated by the Constitution. Article 1, Section 7 of the Constitution states that every bill, resolution, order, or vote, that is to say, anything that is to have the force of law, must go through a particular process of being passed by majorities in the two houses of Congress, signed by the president or vetoed, and if vetoed, a chance for an override of that veto is offered to Congress. And there are certain technicalities like pocket vetoes and a bill becoming law without the president's signature, but there's a concrete process. And it is the process that is stipulated in the Constitution by which policy can be made. However, in the modern administrative state, there are multiple avenues for policymaking, and like water flowing downhill, if one of those avenues is blocked, then one can simply find another path. In the 2010 election, Republicans took control of the House of Representatives. One of the immediate consequences of this election was the fact that the Democrats' cap-and-trade bill, which was their carbon emission trading program, became stalled. With Republicans in control of the House of Representatives, that bill was never going to be passed. Immediately after that election, a reporter asked President Obama what he thought about the future of his cap-and-trade program, which after all was one of the highest priorities of his administration in 2009-2010, and really only got sidelined when the Affordable Care Act took much longer to pass than anyone had anticipated. Obama's response was as follows: "There's more than one way to skin that cat."
So I think it's too early to say whether or not we can make some progress on that front. I think we can. Cap and trade was just one way of skinning the cat. It was not the only way. It was a means, not an end.
And Obama here was revealing to us an important truth, and that is, again, if one path to policymaking is blocked, there's always another. In this case, the legislative path was closed off to the Obama administration, and so they simply shifted gears and began to accomplish the same substantive goals through the regulatory process. The Environmental Protection Agency began promulgating regulations which were purpose-built to do the very things which the people, through the election in 2010, had told their government they did not want done. And so that's just one example of how we can find alternative legislative or policymaking processes when one path or another is closed to us. Let me briefly go through some of the different ways in which government can make policy today that are not necessarily dictated or allowed by the Constitution. Now, the legislative option is still open, the traditional constitutional legislative process. And an example of that would be the individual mandate in the Affordable Care Act. That's actually expressly in the bill. That's an instance where Congress concretely legislated and provided the administrative state and citizens with clear guidance on what was expected in order to be in compliance with the law. But there are so many others. Congress can use the budget process, which is an alternative legislative process. And in fact, Obamacare itself was passed using a feature of the budget process as it exists today, known as reconciliation, which allowed them to sidestep the Senate filibuster. There simply weren't enough Democrats to avoid it through simply voting cloture, so they used reconciliation so that they did not have to get 60, but only 51 votes. Oversight can be used by Congress as a tool as well. Congressional oversight, which takes many forms, can be used to influence policies that are made by regulatory agencies without having to go through the process of actually passing legislation. The president can issue executive orders, as for instance, Obama's Deferred Action for Childhood Arrivals program, where afterwards he says, "I took an action that changed the law." So he's admitting that I effectively did something legislative simply through the executive order process. There are also instances where Congress can pass legislation, but the effect of that legislation is to transfer policymaking power to the president. And if you think about examples of that, you have Obama's unilateral intervention in Libya, which was made possible under the War Powers Act, which provides the president with definitive authority to initiate hostilities abroad for a certain limited period of time and in limited ways. Another example of this would be the various orders that President Trump has issued, which have had the effect of altering tariffs with regard to various goods and various countries. Congress, over the past century or more, has transferred to the president the authority to make certain tariffs within certain ranges. We also find examples of old royal prerogative dating back to the period of the Tudor and the Stuart monarchs in England. Devices like the suspending power, by which the executive can simply suspend the operation of a law that was enacted by the legislature. In 2014, the Obama administration announced that they were simply going to suspend the operation of Obamacare's employer mandate for 1 year. They had no legal authority to do such thing. They simply decided that they weren't going to enforce the law for 1 year. And it was done for transparently political reasons, to try and delay the political fallout of the employer mandate until after the 2014 midterm elections. Another example of old royal prerogative is the dispensing power. The Affordable Care Act did contain a provision which would allow the president, through the Department of Health and Human Services, to exempt certain persons and groups from the operation of the Affordable Care Act, which the Obama administration overtly used to reward favored groups. Many of the groups that were deemed not responsible to comply with the Affordable Care Act's provisions were labor unions that had heavily supported candidate Barack Obama. Courts can make decisions on substance that affect the operation of the law. They can make decisions on process, such as in Massachusetts v. EPA, where the Supreme Court did not regulate carbon under the Clean Air Act, but they ordered the Environmental Protection Agency to do so. They told them that you must do this in order to be in compliance with the act. Agencies can make rules like the EPA's Clean Power Rule or the Affordable Care Act's contraception mandate. The contraception mandate can't be found anywhere in the statute passed by Congress. It's simply a determination made by the Secretary of Health and Human Services that these services must be provided in any health care plan which is sold in the United States. Agencies can interpret law in ways that has the substantive effect of changing what that law means. So, for instance, the Environmental Protection Agency and the Army Corps of Engineers have exercised the broadest latitude in defining the meaning of terms like wetlands and waters of the United States, and they've done this in a way that dramatically expands their power. Legislation can be made by gathering together all of the various interest groups that may be affected, a technique known as interest group liberalism. The corporate average fuel economy standards promulgated by the Obama administration fit this bill perfectly, where we sat down the regulators, relevant elected officials at the state and federal levels, auto unions, automakers, public interest groups, environmental activist groups, and we said to them all, come up with something that suits all of you. And what we got was something that suited the various private interests, at least some of them, but one's left wondering, where is the public interest in that kind of legislation, and where is the constitutional legislative process? Administrative agencies can issue informal advice to regulated parties, informing them that they're going to interpret the law in a different way. The Department of Education was able to initiate the campus sexual assault tribunal fiasco simply by sending a Dear Colleague letter to colleges and universities informing them that in the future, the federal government would interpret Title IX to include rape and sexual assault, and telling them in great detail how to set up tribunals, what evidentiary standards should they use, what rights do the accused and the accusers have. All of this was laid out. The universities did not simply wake up one morning and decide to create a new nightmare for their students. It was imposed on them. But it wasn't imposed on them through the legislative process or even through the regulatory process. It was just a letter generated from an office inside the Department of Education. The federal government can use treaties to bypass the legislative process, like the UN Small Arms Treaty or various climate protocols, if they had ever been ratified. If the treaty process is too hard, then the president can simply use a device known as an executive agreement to bypass the treaty process. And an executive agreement is simply an agreement with another country that never gets ratified by the United States Senate. It has all the force of a treaty, and therefore all the force of law, but it has no grounding in the Constitution and no requirement that the Senate ratify it. The point is, as you can see, that there are well more than a dozen ways to make policy, and very few of them, if any, beyond the ordinary legislative process, the treaty process, are actually sanctioned by the Constitution. And even those are readily susceptible of abuse and are readily abused in the name of the modern administrative state. Finally, not only is the modern administrative state anti-constitutional, it's pre-constitutional. The modern administrative state attempts to justify itself on the grounds that it is a necessary, novel, unique response to the unique problems of the modern world. But in fact, it's nothing more than a return to the kind of absolute government that people experienced before the development of the idea of constitutionalism and constitutional government. In other words, the administrative state operates by the arbitrary will of the rulers. The legal theorist Roscoe Pound, as far back as 1939, realized that the administrative state means that there are no laws, but only administrative orders and ordinances. And, quote, whatever the official does is itself law, even if the outcomes vary from case to case. And there are progressive theorists like Herbert Crowley who brag about this as a feature of the system. He says, why do we have to be concerned with consistency and impartiality? The goal is, to use a modern term, social justice. And so whatever outcome leads to social justice is the outcome that we ought to obtain, even if that means, in terms of legal principles, making contradictory rulings. What it means in practice is that the people are systematically deprived of the legal protections of constitutional government. And here again, some examples will be very useful. The Occupational Safety and Health Administration asserted for years, until it was told otherwise by the Supreme Court, that there were no Fourth Amendment protections for businesses and for the operators of workplaces. If federal inspectors showed up and wanted to check for OSHA violations, they didn't need a warrant. They didn't need to give any kind of notice. They didn't need to state what they were looking for. They did not need to prove any probable cause. They could simply show up. And if you operated a business there and you had workers, then you were compelled to let them in to search the premises looking for anything or just to look around. those campus sexual assault tribunals that I mentioned a few moments ago are notable for their lack of ordinary constitutional protections for the accused. There's no right to confront one's accuser, no right to counsel. A lower standard of guilt is specified. That is to say, in an ordinary criminal prosecution, the prosecution must meet the reasonable doubt standard, or that is to say, it must be proven beyond a reasonable doubt that the accused is guilty. In the campus sexual assault tribunals, however, the evidentiary standard is what's referred to as preponderance of the evidence. That is, if the decision maker, the judge, the jury, whomever, decides that there's more evidence in favor of guilt than of innocence, then the determination is that the accused is guilty. This is a far lower standard of evidence than is required in ordinary criminal proceedings. In the Environmental Protection Agency, the EPA has asserted, again, until told otherwise by the courts, that persons who are in the crosshairs of the EPA do not have access to the federal courts in order to obtain redress for their grievances against the agency. The government can impose fines and impose civil penalties, and there's nothing that the accused, the person fined, can do about it unless the EPA consents to allow that person to bring suit in federal court. There's also no protection against excessive fines. In one recent case, the defendant was told that if they refused to comply with the EPA's dictate, then they would be fined $37,500 per day. And this was a private citizen, an ordinary homeowner. The case is called Sackett versus Environmental Protection Agency. The EPA also told them that if we allow you to go to court, we are going to double the fine to $75,000 per day. The administrative process is also anathema to the ordinary process of adversarial courtroom conduct, where you have a prosecutor and a defense, and their job is to present evidence to convince a judge and or a jury of guilt or innocence, of culpability. That's replaced with the system of criminal procedure that is used in the civil law courts of continental Europe, which is also known as inquisitorial process, whereby the judge also functions as an investigator and a prosecutor, rather than simply as an impartial arbitrator. Now, the goal of constitutional government, as it was originally developed in the modern world, in England and brought to America in the 17th and 18th centuries, was precisely to prevent this kind of arbitrary government. The struggle between crown and parliament in the 17th century was a struggle over the divine right of the monarch to rule, right? Who rules? Does the king rule absolutely simply by the grace of God, or is power checked and limited and vested in the people's representatives? The goal and the victory that was obtained in the Anglo-American world was to eliminate the power of the government to be arbitrary. Now, in contradistinction to the English-speaking world, continental Europe never developed a constitutional tradition. Instead, countries like France and Germany witnessed the development of centralized administrative absolutism. The progressives, for their part, in the 19th century, were as enamored of the continental systems of bureaucracy as they were of the English system of parliamentary government. And so when they studied in Germany, they brought the European administrative model back to the United States and attempted to impose it on our constitutional system. So what we see then is that the only thing that's changed between the 16th and 17th centuries in England, and indeed in most of Europe, and the administrative state today is the type of person that composes the ruling class. That is to say, in Tudor and Stuart England, you had an hereditary monarch and an hereditary aristocracy. And in the modern administrative state, you have a self-selecting elite based on education and technical expertise. But in both cases, you have people outside the control of the people and their representatives who claim unlimited authority to rule over us according to the dictates of their own will, which they claim is superior to the will of the average person. Okay, The second half of the administrative state that we need to think about a little bit today is the notion that the administrative state is an oligarchy. Now, I've suggested in a previous lecture that the founders of the administrative state wanted to establish a kind of aristocracy, not a hereditary one, but an aristocracy nonetheless, a country where a technical and scientific elite with superior education and insight into the progress of history would make decisions for the rest of us. What we got in practice was simply an oligarchy, which, as I mentioned before, is a kind of government where the few rule, but instead of ruling for the good of everybody, they rule for the good of themselves. What has developed in the United States over the course of the 20th century and into the 21st century is a distinct and insular social class that with each passing generation becomes more and more apart from the people whom they purport to rule. They tend to live together in coastal, urban, or university enclaves. They have the same tastes and interests. They go to the same institutions. They learn the same things. They marry amongst each other. And so they form a discrete class that's very different from the people whom they purport to rule. Perhaps an interesting example from the world outside of politics that can help us understand this is to look at an old movie called The Grand Illusion from 1938. In that movie, we see a couple of French officers who are taken prisoner by a German officer. One of the French officers is an aristocrat, and the other is a common man. And what we find out is that in this World War I prison camp, the German officer and the aristocratic French officer come to realize that they have more in common with each other than the aristocratic Frenchman has with his plebeian friend with whom he was captured. That is to say, this Frenchman has more in common with this German in the middle of World War I than he does with another Frenchman. They're so separate, the two Frenchmen, from one another that they don't really understand each other. They don't share the life experiences, just like, in many cases, our ruling class does not share life experiences with the people whom they purport to rule. Right? They go to different institutions, they have different ideas, they've never been faced with the same challenges that characterize life for ordinary working and middle-class Americans. And as a result, as they grow more and more separate, they tend to manifest greater and greater contempt for the people whom they would rule. So that Obama can say that people in the heartland of America, quote, get bitter. They cling to guns or religion or antipathy to people who aren't like them, or anti-immigrant sentiment or anti-trade sentiment as a way to express their frustrations. Or Hillary Clinton can refer to them simply as, quote, a basket of deplorables. One CBS News editor, in the aftermath of the 2016 election, said that media treatment of Middle America was, quote, like colonial administrators reporting on the natives, unquote. We think we're the enlightened ones, they say to themselves, and everyone else and everyone who doesn't agree with us and have our background is somehow inferior. Now, one thing that distinguishes our new oligarchy from traditional oligarchies is the fact that they are able to maintain their power by distributing largesse and benefits to various clientele groups who support their rule. Now, probably the most obvious of this are people who receive direct financial benefits from the government, and this would include both welfare recipients and government employees, who in many cases are among the most active supporters of the ruling class and the administrative state. But there are also numerous non-monetary beneficiaries who obtain benefits from the administrative state and therefore are inclined to support its perpetuation and its expansion. Women and minorities in various groups are covered by affirmative action programs. The LGBT community seeks to use the power of the modern state to impose its definition of freedom and autonomy on the rest of the country. There are activist groups like the Sierra Club, the Natural Resources Defense Council, the National Abortion Rights Activism League, that use the power of the federal government to perpetuate and to propagate their ideologies and their favored projects. Large corporations receive bailouts, trade agreements, favorable regulations, and government support in eliminating potential up-and-coming competition. In other words, what we would refer to today as crony capitalism. And so we see that all of these groups lends support to the ruling class. Even if they're not part of that class themselves, they benefit from it in such a way that they have a distinct incentive to support it. Now, what this means in practice is that the ordinary person, the working class American, the middle class American, who is not one of these groups and who does not have the connections to ascend into the ruling oligarchy, is effectively disenfranchised. Elections don't really matter. Policy is made by an elite that is effectively outside of the electoral process. There's a great old cartoon that appeared in the New Yorker that showed two bureaucrats at desks, and between them was a window, and in the window was the White House. And one of them looked at the other and said, "Just think of it, Larry. Presidents come and go, but we're forever." And that's a wonderful attitude, or a wonderful distillation of the way the administrative state works. So what about elections? So what about the people? We do what we do, and it doesn't matter who's in power or what the people think. Policy can hardly be said to be made for the people. We have endless wars of democratization in which ordinary people send their sons off to war to die for the benefit of the neoliberal world order, which is established by a transnational ruling class of which our own ruling class is but a part. We have free trade agreements that destroy the viability of middle and working class families. Cultural revolution, marriage, sexuality, divorce, that wrecks the integrity of the family, which is, morality aside, the foundation of ordinary people's stability and prosperity. We have open borders that ruin American workers and transform the American way of life. All of these are advocated by our ruling oligarchy of both parties, and both seem to be opposed by the ordinary people of both parties. And yet, here we are. Right? The policy is made anyway. So a good place for us to end is to put all of this together and to recognize that despite its grand promises and despite its assertions that it is necessary for a modern world to be governed by a modern administrative state, a modern administrative state is simply a return to oligarchy, government by a ruling elite for its own benefit, unconstrained by law or constitutionalism.